Justice in Motion, the Legal Lowdown with Jared Jones, the noble attorney.
Yep, every Wednesday we have a chat to our noble attorney, Jared Jones. I wonder if people could walk up to you and just go, Mr. Noble. Jared, how you doing?
Good itself.
Lekker, man. I wonder if this sticks, right? Are you like, do people just walk up to you and go, are you Mr. Noble?
Look, it's starting to happen. People have, in the last few years, started to recognize more and more. So
it means we don't take nonsense. Okay, for our new listeners, what is the mission every week, Jared?
Okay, so Sam, the mission is quite simple. It is to legally empower people of the general public about their legal rights and what they can do in various situations.
100%. And today, another doozy of a topic. We're looking at municipal mess-ups when local government gets it wrong. Okay, before we even go into what the law says, what have you been seeing? Why are we talking about this today?
Okay, so Sam, the simple issue is as follows. In the last number of years, I think anyone can count it pretty well, get the genesis of this quite clearly. Since about the early to mid 2010s, we've seen a steady decline in service delivery in the country on a number of issues: the conditions of the roads, the various issues regarding refuse, stormwater. The service delivery has gotten steadily worse and worse, and it's got to the point where I think municipalities are inundated with a multiplicity of different cases against them for some form of negligence one way or another. So, you know, this is quite a serious issue, and I think it's quite pressing for those of us, especially at this moment in time, and municipal elections around the corner in the next few months.
100%, I love it. So, okay, let's start with that very important thing. What does the law say?
Okay, so the law is quite clear in terms of the relationship between municipality and service provider. One does have recourse against them for negligence. So effectively, where a municipal body has a duty of care, legal duty, they are two different concepts, but the main thing is it applies to them in both regards, in that where they are negligent in maintaining certain infrastructure and that causes injury to a person's property or themselves, they do have a claim against the municipality. The waters do get distinctively muddy when it comes to electricity provision, but insofar as your potholes are concerned, holes in the pavement where there hasn't been proper cordoning off of that hole, if you get hurt in that, you've got a personal claim for damages against the municipality. It's quite clear there are recourses in terms of the established law.
That is crazy. So, okay, let me ask the silly questions, right?
No, go for it.
So, parks that are dirty, I am on a swing and I get hurt because it's rusty and it scratches me up and I end up having to go to hospital for shots and whatever and everything else.
Well, look, that is part of municipal ground as far as I'm aware in most situations. Again, one would have to establish that first. Who is the body in control of that particular park? What was the extent of the negligence? So you've got a quantifiable claim for damages insofar as hospital is concerned, or the injuries are concerned, hospital expenses are concerned. The main thing is proving the facts, showing evidence of that rusty swing or whatever it was, and then lodging that claim against the municipality. There are prescribed measures of going after municipalities and state bodies, which is in terms of the institution of certain proceedings against legal proceedings against certain organs of state act. You would have to, within 6 months of that, lodge a formal notice in terms of that act against the body concerned, and thereafter issue summons against them to claim for those damages.
Another silly question. Unlawful bylaws. Please explain.
Okay, so simple thing is, it's not so much unlawful bylaws as it's non-compliance with bylaws for the most part.
Okay.
I've seen it quite often in certain jurisdictions where there are prescribed procedures in terms of your municipal credit control bylaws, where one has to issue a pre-termination notice before they start restricting your right to electricity. Breach of that would be a breach of their own bylaws. And again, remember, all these bylaws are subject to Municipal Systems Act, Municipal Finance Management Act, or in this particular situation, the Municipal Systems Act, and of course, of all things, yes, and then naturally the Constitution, which informs all of these things at all relevant
Section
times.
152.
That is correct, yes.
Yeah. Okay. This is the silly question round. And this is interesting, right? So one of the things that you list that service delivery failures, like consistent water outages, may justify a legal claim. But have you seen anything related to consistent power outages? Is that also liable for a claim? Because I know at some point, I remember some stories where a couple of business owners were going up against local municipalities saying that they've damage their businesses because of the constant power cuts.
Yes, well, you see, there was a case, Eskom Holdings and another versus Swan and Aruka. It's a SCA decision where they gave us a crack around about this year, or say last year. So, unfortunately, they went after the wrong body. They went after Eskom. And naturally, as with the early cases in any constitutional consideration like the right to life, it's subject in certain circumstances to a limitations clause. So, effectively, they said there is a difference between breaching a duty to the public or to certain parties and the ability to supply it. So that's where the SCA in that decision said there was a limitation to that particular right.
So who should they have gone after?
Well, look, I think the main thing is I would have included the local municipality concerned with that issue. 9 times out of 10, the failure to produce, and this is a little hack for some of those who may not be in the know, there is, in certain circumstances, or possibility in certain circumstances, where a municipality will have restricted access to electricity because of a debt owing to a municipality. I've come across stuff in my practice where that has happened. So it is all about the reason why the electricity is not provided. If there is a fundamental reason, such as in the Eskom case, where there was a overburden on the infrastructure, well, then there's only so much Eskom can really do. So again, I would personally, in addition, unless Eskom is the direct provider, add other parties to that litigation.
Very interesting. The other thing, so this is obviously me from a very layman's perspective asking this question. I know in America and other places, class action lawsuits seem to be a thing. And I've seen too many legal shows to kind of know what it means. But the idea that a community can launch a class action lawsuit when widespread harm occurs, has that happened? I know there's been moments where it's happened, but I think of bigger things like maybe a Marikana issue.
Correct.
But have we seen this from a community perspective yet?
So look, it's things that
are growing.
It is something that does happen in the private sector fairly regularly.
Yes.
When it comes to the expansion of that against state organs, there's actually an interesting article I read this morning from an undergraduate student at Pretoria, University of Pretoria, one T. Scott Ngoepe, where he does a paper explicitly on the potential of using Section 21 of the Consumer Protection Act for the purposes of launching actions against the state, and more specifically later on in the article or in the paper, class action suits. So in other words, the failure of the state to in fact provide in terms of the act. There is case law that he does go into that article about, but again, unfortunately in that situation it was yet again against Eskom, and the deflection in that particular case was, well, we don't actually provide the electricity directly. There's no consumer relationship. So look, my one thought on that was to expand the issue of direct or indirect, or the person that bears that in the common law term, but the illegal duty. But the point is, there is contemplation and discussion, and discourse over the expansion of class actions against the state.
Oh wow, that's very interesting. Okay. But I mean, let's be honest, a class action lawsuit is not an easy thing. It's very complicated, right?
Well,
from my limited understanding.
Absolutely. Look, the only thing I could contemplate in the situation, while it is, and there's a difference between the legality of it and just practical solutions. One can do that as a class action against an organ of state or a party that's supposed to be providing. The point is, you'd have to establish legal duty of care, the fact that they breached that, your quantifiable damages. So it's not insurmountable. It does take time. A class action like that is going to be multi-millions and most likely in the High Court. And now we, again, as I've mentioned before, are required to mediate these issues, even with commercial entities, before going to trial.
Okay. the silly round is over. Let's go to our modern case study, right?
All right.
The pothole battle. So Tabo crashes his car into a giant pothole that has been left unmaintained for months. Despite repeated complaints to the municipality, he sues the municipality for damages, arguing their failure to maintain the road is negligent. Okay.
So the main thing is, number one, is there a duty on the municipality or duty of care to that person, to the general public, or that organisation to the general public, to in fact maintain those potholes, or those roads, or so on and so forth? If the answer is yes, the natural thing is, did they do so? If that is in fact a no, and they failed to adequately and timeously identify and fix that, that is a problem towards negligence. And then naturally there is the injury to the person that has been affected by that.
Positions.
Correct, and obviously that the causal link between that and the failure to actually repair this pothole. And then another thing to consider is, in terms of a usual defence, which would usually be thrown up in these cases, is contributory negligence.
Which means?
So, in other words, the person concerned also had a duty to look out for themselves that there was something there.
Okay.
But then again, let's just say in the case of a pedestrian situation, and if things aren't clearly identified or marked out, it may not be easy a case to prove for the state on that issue. But again, where you can prove negligence and that there was a duty on that, a legal duty care on the other side, particularly the municipality, to maintain that infrastructure, then you can then go towards the quantum aspect of it and say, these are my damages, such damages as I have proved the state must now pay for.
And Jared, would the proof be that, let's say, Tabo pothole, is that in the form of video? Is that in the form of pictures? Is that in the form of, this is how many times I've sent this email? Is it kind of the documentation of it?
Yes, documentation, as always, is everything.
So
your pictures, video, it's important to take these things as close to the accident date as possible, if not on the day. Report the thing at the SAPS, have a record of that, an accident report, OB report, if it is a pedestrian or other incident on the side of a curb. Make sure you always have a paper trail of everything that you're doing.
That's very, very interesting. Okay, so one then, and I want to be careful with my wording, right? Because I think it's somebody sitting there and going, oh, I might have a case against this. Can you list for us the stuff that is, or maybe one or two examples of the stuff that's incredibly difficult to prove? So we've said if you document the pothole as close to the accident, that's kind of something easy. But what do you think is, like, one of the things you've listed here is, for example, when your electricity bill is higher than your rent.
Okay.
What is difficult to try and prove and take the legal route?
Okay, so the issues of disputes over electrical and other usage as a landowner or
Because we
tenant.
have this issue too.
Well, this is a major thing. The problem is, in those processes, you are now abiding by the municipality's credit control bylaws. Following that process for a dispute, it's often an internal one, and it's often one plagued by delays or non-response. So in terms of those bylaws, one, if there is non-response, there's usually recourse to the provincial level to intercede if it's beyond 90 days, and or you can go to the local ombudsman that has jurisdiction over that particular municipality to deal with those disputes. The main thing you're going to have an issue with is obtaining the necessary information to prove your case. If there's been irregular readings or false readings, you need to go to the municipality, you need to pay for copies of, or get copies of the readings so that you can prove your case. So
you're saying pick your battles.
Pick your battles, and also remember, if you're going to be dealing with an internal dispute in terms of administrative law, like the electricity dispute, that starts with the municipal level. If you don't get recourse there's ombudsman, provincial level, and if necessary, go straight to legal. But that will usually be in the form of relief at the High Court.
Yeah, and then obviously some of us have more time than others. So if you've got the time for that, if you had really is a bugbear of yours, you're happy to follow that route. But most of us don't.
Well, this is the thing, the alternatives are, and I would strongly recommend this, is get legal representation in the matter to assist you with those particular situations, because or someone with legal expertise in those particular matters, bearing in mind obviously lawyers have accountability processes in terms of regulation. But the point is, it's important, if you don't have that, to get someone who's experienced and skilled in those particular matters to escalate it so you can come to some sort of resolution, and obviously manage your expectations. If you're fighting over 1,000 rand over 1 month, it might be a serious thing for you, but that's something for you to assess when picking your battles with the municipalities.
I'm laughing there because I have family members who've gone down that road and they've never had success.
No, 100%.
They've never. I want to just mention that. One of the things that I also wanted to, obviously, so part of the practical tips is for residents is always log service complaints, keep proof photos, receipts, complaint numbers. But here's the thing, and I don't want to be that guy, but I'm going to be. What is a reasonable time or expectation if you do go the legal route? So you said the class action can take years.
That is correct, yeah.
Yeah, that could potentially take years. But if it's kind of lower tier stuff, what should one expect? Because I often heard families say, well, we've been at this now for 9 months and there's been no resolution and they're frustrated. And I've often wondered, is there a time frame that this should be reasonably dealt with?
Well, yes. In terms of most of the bylaws, it would be 90 days.
90 days.
So, but generally, from personal experience, I would say you could stretch that out to a year or more easily.
Yeah, that's what I've experienced with family members.
That's the unfortunate reality of it. So, but it depends. As long as you keep on consistently communicating, attending to address the issues, provide whatever information you need, let the municipality make a determination, or the dispute committee, and then from that, depending on the decision, you can escalate it higher to either the ombudsman, alternatively to the court system to resolve that dispute.
Okay, as we wrap up, so let's talk about the myths, right? So myth 1, if the city ignores me, there's nothing I can do.
Well, that's not correct. The point is, number one, if you're not getting it through email or telephone or however you're doing it, you need to take whatever reference you can. You go into the care centre of that particular municipality and you request to speak to people on the ground. Particularly your credit control departments are usually the people that are going to be dealing with these disputes, and then get direct emails and keep on pressing. Leaving the matter is not going to resolve it. It will make it worse.
Myth 2, it's too expensive to sue the municipality.
Well, look, it's not necessarily too expensive. It depends on, firstly, the issue you're dealing with in the first place versus the expenses. And also there are some organizations that will either do it on a contingency basis, that's certain law firms, and or if you generally cannot afford it, you can reach out to organizations such as Legal Aid, the Legal Practice Council, who can allocate pro bono or free matters to certain law firms, or probono.org and other such organizations like law clinics.
And then our final myth as we wrap up. If it's just inconvenience, I can't claim. So if I'm annoyed by it.
Well, not necessarily. The inconvenience, it depends the extent of the inconvenience as well. Usually a lot of this sounds in money, but I think we're getting to that juncture more and more where we need to press things beyond just a monetary aspect of things.
So, but specifically, if you can prove yet again through documentation that it's caused financial or reputational harm, then it's actionable.
100%.
So documentation is everything.
That's
As
good.
always, sir, interesting conversations. I might have to rethink some of my own challenges that I face on a daily basis. Where can people get hold of you?
Thank you, Sam. You can reach us on www.jdjattorneys.co.za.
I love it. I feel like it's a masterclass every week, because you think in a way that some of us don't even think about. And hopefully it's empowered you to understand that you actually have rights. But yet again, documentation is everything. That should be on a t-shirt.
Justice in motion, cutting through legal noise, one truth at a time.